Then, okay, sir.
Okay, madam.
Okay, sir. Good morning, everyone. I welcome all the dignitaries to the one-day workshop. On behalf of Mother Theresa Institute of Engineering and Technology, I welcome you all for the one-day online workshop on intellectual property rights and IP management for startup organized by the Department of EEE. I would like to introduce our today's chief guest, Dr. Bosubabu Sambagaru, who has been working as an assistant associate professor in the Department of CSE at Lundy Institute of Engineering and Technology, Visakhapatnam. Sir is having 11 years of experience in teaching and research. He has a good knowledge on future internet architecture and technology, artificial intelligence, astronomy, cosmology, space research, blockchain, cloud computing, Internet of Things, and different academic subjects. Sir completed his bachelor's at Andhra University, Visakhapatnam, and MCA and MTech at JNTU, Kakinada. Sir received his doctorate from Andhra University, Visakhapatnam, and pursuing one more doctorate in artificial intelligence for deep space network communication from IIIT, Rajasthan. Sir was honored with Outstanding Research Award in the year 2019 and Young Scientist Award in the year 2020 and Outstanding Research Award in 2020. These rewards, sir, has been achieved from various reputed national and international research organizations. Sir, Bosubabu sir, we welcome you today's workshop and I hand over the session to the principal, sir. Thank you, everyone.
Thank you, Divajan madam. Honorable Chairman Sri M.R. Sunil Garu, Secretary and Correspondent M. Ravindra Babu Garu, Director R. Rajendra Reddy Garu, HODs, Director of Academics Sharwan Garu, my dear faculty members, good morning all of you. First, I would like to thank today's chief guest, Sri Bosubabu Garu, for accepting our invitation to be as a chief guest for this one-day workshop on intellectual property rights and IP management for startup. Thank you, sir, for accepting our invitation and to be as a chief guest for our one-day workshop. And I would like to thank all the participants who are participating in this workshop. Actively participate in this workshop and learn new things which Bosubabu sir will deliver today regarding intellectual property rights, and make use of this workshop for all of our coming activities. With these few comments, I want to say thanks to Bosubabu sir for accepting our invitation. And I want to thank all the participants. And also I want to inform HODs to intimate all the faculty to join in this workshop. With these few comments, I would like to start the session. Bosubabu sir.
Sir, thank you very much, sir. It is really honor to me. And this workshop is definitely helpful to you. Before this workshop, your surrounding colleges, MITS, Madanapalli, and Vasavi Engineering College also, the same workshop we are conducting as a keynote speaker. I surely give residence to this workshop. Gives immense knowledge from my end. May be useful to how to publish, how to file your papers. how to file a patents and how to draft and the initially this workshop we will plan to divide into 3 categories. First one, theoretical mode. Second one, experimental mode. Third one, how to the IP rights are visible in various factors and how to the IPR rights utilized in a commercialization way and along with educational sector. And I will give the demonstration, live demonstration on in my dashboard, how to file a patents and the procedure and the drafting procedure, everything I will show you. Let me know if any doubts. Okay. Can I go through, sir?
You can carry on, sir. Thank you,
Okay,
sir.
thank you, miss. My screen is visible, sir?
Yes, sir, it is visible. Screen is visible.
Okay. Now we are going to the further one. Today we are discussing about the topic Today we are discussing about the topic intellectual property rights, generally known as IPRs, and IP management for especially startups along with education institution. Here, any education institution in any educational institution file a patents and how it is commercialization, how the uh, income generation from the innovative ideas and how transformation comes from one ways to another way. This is the main thing. In this video, in this lecture, we will give the clear idea about the basic information like basic information idea about the IPR topics. Okay, present in this video, the presentation topic is Introduction to IPR and Types and historical perspectives and evolution of IP means intellectually laws and Indian IP laws along with international IP laws and international PCT. What is the PCT? Okay, and we will go through hands-on experience and here hands-on experience we are categorized into planning to either how to file a patent in my dashboard along with how to write a draft like a patent draft. Okay, this is the main thing. Everyone must know about you have idea but how to file a patent and you have idea how to draft a work. This is the main thing. In the way, what is the national education policy along with the national IPR policy? This is the main thing. Here, everyone knows about what is IPR. Here, IPR is generally known thing, very simple. And here, IPR comes under patents, copyrights, trademarks, geographical indication, and trade secrets. Okay. The here, what is the intellectual property? Here, intellectual means intelligence. Property means where the property belongs to or who are belongs to the property. Either physical property comes to land property like this, buildings like this. Here, the property belongs to intellectual. That means knowledge. Okay. Here, the first thing, creation of human mind. The creation of human mind means divide. These are gives to two things: discovery and innovation. Innovation comes is very individual way, but discovery based on innovation, discovery comes the factorial matter. Here, knowledge, sir, I'm audible, sir. Please confirm me.
It is audible, sir. Audible.
Okay, okay. Thank you. It's and knowledge asset created through the manufacturing of ideas. Here, manufacturing means no manipulation. Why? Because if you are planning to file a patent in digital, previously the patent filing system completely not digital. Okay, here completely digital system. Then if you have any plagiarism policy, if you have any content related to the other innovator work, then immediately they classify your work and indexing your work, that their work, then immediately they give the alert. That means warning. Gives a like what we call warrants, IP warrants. The IP warrants completely, IP things and IP laws completely handled by IP lawyers. Particularly special judiciary system also there. Okay, the complete management and complete IPR management handled by IPAB, Intellectually Property Appellate Board in India. Website is ipab.in. Okay, if so many people are planning to file a author positions, like so many consultancies are going to filing author position 1, author position 2, author position 3, and so many, but it is not good. Why? Because that works belongs to not done by you, that works not that works not designed by you. Why? Because they are looking for filing only money. Okay, if their classifications, if there any similarity works related to the other people, then immediately you are taken action from the IP laws with the non-judicial non-bailable warrant. Okay, it's punishable up to 7 to 15 14 years. This is the main thing. Okay, it is terrible, it is tradable commodities like any other right. IPR enforceable by laws like intellectual property appellate board. It's handled, and IPR plays more key role, an important role, and asset for enterprises than physical assets. Why? Because most of the patents are filing only industries. Why? Because those are planning to design a product and they are planning to sell, they are planning to marketize, they are planning to transform into technical domains like technology transfers, anything. And tool for business competitiveness, like means I will show you everything, no worry. Here, the national health policy, national IPR policy motto is new wealth for nation. This is our national motto. And what is the national and international dimension of IPR? Here, IPR governed by national laws and rules of given based on countries. Every country designs and based on the circumstances according to the national policy. Okay, yeah, and the national policy, the who host and who organize the national IPR laws and IPR that IPR like governing body called as like regional office. Okay, and here international convention ensure minimum rights and provide a certain measure for enforcement rights also by the contracting states. The states means countries. Here the patent. What is the patent? I will explain everything in detail in every way, and this is the basic thing. What is patent and what is designs and what is the trademark and what is the geographical indications, what is the copyright, and here historical importance of the who filed the patent and who give the total working policy and division structure. All those things I will explain in any in detail manner. Okay, please go through, please walk with me, and I will explain everything in another slide also, each and every either patent rights, copyrights, and all those things. Okay, now what is patent? Here, patent is a statutory right granted for the innovation to the who are innovator and is assigned for limited period of time, excluding the other from making, using, offering for sale, like means technology transfer, selling, and are importing any product covered by a patent. Okay, if patent for process then from using the process of your product obtained by the process and above actions. That means patent is a completely innovative idea. Here, patent categorized into so many factors like utility patents, design patents, and commercialization patents, industrially based patents, and so many patents are plant-based patents. Like we made innovation patents, utilization patents, normal patents, ordinary patents. Here, that time, so many types of patents there, but filing process are different. Ordinary patent, conventional patent, and PCT patent, and PCT commercialization patent. In this way, 7 types of patents filing mechanism also there. Here, based on your requirement, they are planning to file 2 types. First one, provisional filing. Second one, complete filing. That means generally called as a professional, like professional specifications. Second one, that means generally called as a primary specifications. Second one, complete specifications. Here, if you have idea, you are planning to file a, and you want to planning and you want to protect your idea from initial way. Then you want then filing go through filing, and it's secured up to your idea up to 12 months only. Okay. Later, immediately we are planning to move the complete specifications. Otherwise, the primary like initial specification
Bosubabu,
immediately.
sir. Bosubabu,
Yes,
sir.
sir.
Sorry to disturb you. Most of the faculty members have been waiting, sir.
Waiting.
Yeah, waiting for join the workshop.
Sir, you are co-host, sir.
But I'm not getting the
No, sir.
features.
Go through admit all. Go through admit all from your end.
Okay.
I'm already giving the option, sir. I will give you in principal, sir, also.
Okay.
Principal, sir, you are also co-host.
I will see. No problem.
Okay, sir.
Okay.
Visible, sir?
Visible, sir.
Okay. Thank you very much.
Visible, no problem.
Okay, sir.
Okay.
Here, when we are planning to file different factors like complete specifications and normal as primary specifications. Here, complete specifications completely based on your idea. You are planning to file complete patent based on novelty and invention steps. Okay, the invention steps also depends on capable industrial applications. Okay, you are planning to file a patent in the date on the date like today, John 1st, 2023. Okay, if your work published after 2 weeks, okay, form there is form 9 or 18 like this. I will explain everything in forms also. And laterally, when you are planning to go through like examination. Okay, patent examination. After the examination, you will secure a patent after 3 to 4 years. Okay, this is the first factor. Okay, another way, Government of India also provide another rule. If you are patent team, if you have any lady, like means women, they give fast examination process. Grant also we plan women innovators, first one. And industry also looking for industrialization way. Third one, education sector, government gives 90% rebate of the patent fees. If you are planning to file a patent through initiation way, and Government of India also reduces 90% fees. This is the best way. I will show you how the Government of India rebate, like to give the discount from the sources. I will show you everything. Please go through. And if you secure, if you are we are planning to file a patent in John 1st, 2023, but you secured a patent through women innovator, like December 2023. Up to the patent will valid for 20 years from the initialization date where we are filing to where we are filing patent on date. Okay, after getting the patent, but they are considered only for patent filing date only. After that, the patent filing date considered as a priority date. Priority date. Where which one they are planning to submit documents like complete specifications and many more things like your the geographical indications like and many more documents are they are required. Form 1, Form 5, Form 1 for application, Form 5 for like innovators, inventorship, and Form 6, Form 9 for publication, Form 18 for exit purposes. And I will show everything, no worry. Okay. And designs. Here, design means only the feature of shape, configuration, and pattern, ornaments like jewelry, composition of lines or colors or combination thereof applied to any articles, whether two-dimensional or three-dimensional or in both forms. Okay, by any, sir, please go, please wait 1 minute, sir. Please wait, sir.
Okay, sir.
Am I audible, sir?
Yes, sir.
Okay.
Okay.
Okay, sir. It's audible.
Okay. Any disturbance is there, sir?
No, sir, no.
Okay. Sorry for interruption, sir. Sorry for the interruption. ఇది పట్టుకొచ్చి సార్ సారీ సార్ ఏ చేయితాయి Please. I'm audible, sir.
Yes, sir. Yes.
Sorry, sir. Some technical issue there surrounding me. Okay. The design patent. I'm audible, sir. Sorry to interrupt you.
Yes, sir. Yes.
Yes, sir, you are audible, sir.
Extremely sorry, sir, from my end. Okay. The design patents, it's completely like several features like shape and configuration, pattern, and the ornaments like gold and any other design, other type of designs. Okay. And design does not include who include what the categorization of include and what is the categorization not include. Like design does not include any mode or principle or constructions like or anything. The building also building plan also not considered for design parents. Okay, this substance made mechanical devices and does not include any trademark as per Section 2 Act 1958 Act. Here, remember one thing, mechanical device. But cases, some cases, if you have any mechanical device in physical, the physical device, they consider for written design. I will show you everything. Your faculty, Krishna Reddy also file a patent. Surely they get surely he will secure patent rights regarding his innovations like mechanical device. Okay, this will require up to 10 years and maybe extension possible 5 more years. After that, every 3 years, it renewal process also required based on your requirement. Industrial designs are of great commercial value because of shapes and configuration and article of an often great selling point of view. And what is the trademark? Here, trademark means a remarkable and mark capable of being presented a geographical and which is capable distinguish goods or service of any person, those of the others. That means your company logo and your college logo also play. If you want to if you want to secure your college logo, if and the industry logo, then go through trademark rights. This is unique rights, like for example, like this. And trademark can be signed, words, Allu Arjun signature, like trademarks. Yeah, also trademark signature and words and like company names, letters, numbers, X, X, SpaceX, Twitter after rename X, and drawings like Mona Lisa painting and pictures and emblems, national emblems like this, and the colors, combination of colors and shape of goods, packaging and sound are any of the applied for applied to goods or services. It's valid for 10 years. There are renewally property particularly in for 10 years for each. Some specification fees also there for renewal fees and filing fees and publication fee and all of these. And what is the geographical indications? Like everyone knows, Madanapalli, Mandrapandu, and Nagpur, Chilpandu, and Palasa Cashew, Tirupati Laddu. Okay, consider as geographical indications. It's like agriculture and natural or manufacturing goods. Dharamvaram, Kanchpattu, and the Pundur Kadi, like this.
as originating and manufacturing in the territory or specific region of the country and region and locality in the territory, where a given quality, reputation, or other characteristics of the such goods is essentially attributes to its geographical origin purpose. Here, two mechanisms also there, authorized mechanism and unauthorized mechanism. Here prevents authorized unauthorized use of registered geographical indication by others. Or the main thing is it's promotional, it's a particular location based promotional, and the particular area belongs to um, belongs to the product where the product came from, and um, the textile industry also government of India also provides some budget to um, generate the income and human power by this purpose. And what is the copyright? Copyright is everyone known as movie copyrights and book copyrights, and the exclusive rights is given for owner and who wrote the book and who wrote the paper. So many people are wrongly think about authorship. Why? Because actually your research paper belongs to your your work. The completely works belongs to you only. Only publication rights belongs to publisher. Hey, the publication rights belongs to only publisher rights. Okay, then copyrights belongs to who are acted as a editor, who are acted as a guest editor, who are acted as a co-editor. The copyrights belongs to that people. Okay, here only you have only authorship only. If you have, if you want to give your paper along with the copyrights, then you initially go through write a process to publication. Clearly mention the publication along with copyright policy. Okay, I will show you everything. Please wait. Here, various types of copyrights also there. First one, typical or original works and collected from the other sources, like unauthorized access there. It is categorized to various factors. First one, literacy works and dramatic and music and artist works and cinematographic films and videos like this and sound recording. Okay, here operates duration and I will explain everything. Its lifetime duration is the lifetime of the author or artist up to 60 years. Okay, or death until death. If they want to extend their services, renewal services, who are belongs to further, like normally. I will explain everything. Here, the most thing is what is the historical perspective of IPR? Where the first, I'm audible, sir?
Yes, sir. Yes, sir.
Yes, sir. Yes, sir.
Okay, please go through carefully. This is the very important point from where IPR started. Then initial way to till now. Where the initial days, how to file a patent, how to protect your work, even bread also, even bread, eating bread also, like a patent rights, a secure patent rights. In initially, according to the sources, like Talapaka Grantham, like this. The Chinese parts exhibit two types of marks in the name of periods emperor and the name of mark of the origin. Before Christ, 2000, 2700 BC. Like this. The first thing is Chinese parts. Next, the usage of stamps on bricks by the Roman. Our Or the bricks also there, na? Some name also there. The usage of stamps on bricks by the Roman bricks maker for the purpose of identification began early 2nd century BC. And during the constructions, they are easily identified where the construction and where whoever belongs to the construction like this. The potter's marks of Greek and Roman times appeared on vessels into the vessels to indicate the origin, destination, along with the identification of the maker. Okay, who were designed, who were developed the things in ancient Roman Greeks, ancient Roman time. After that, one of the finest examples, both ancient and modern trademark using was barber's poles. Barber pole in India. Barber poles in India, which is used to indicate location of business. During the 10th century, merchants' marks also referred to as property marks. Portuguese mark in Cochin along with guava was used to prove ownership rights of goods. In 1266, the English government enacted a law for protecting who are the first secured European patent, like like backer, every backer, like so many backers also there. But who are secure the complete protected manner, like that time backer business are very famous business in that time. That means who are who works the whole is work for each and sorted for the bed in order bed. In the way, customers who are identified, the works belongs to that backer, that works belongs to that backer, KFC. Nowadays, KFC, like this. Okay. In early 13th century, copying of values marks become so common and injurious that infringement here identified infringement. This is the judicial term. That infringement was made as a misdimension in some cases even felony. That means copying of the original novelty work with another one. Here, 14th and 15th century, many people are observed dramatic emergence of merchant and craft guilds, trademarks like symbols, East India Company, British India Company, like this. Logos and pirates also gives they secured like protected emblem. Pirates also. East India Company EIKCO like this. Logos began to appear identification of goods and services. East India Company like this. And the first IPR uh, infringement like IPR um, case filed against Southern and Howe 1670. The first one is in the landmark cases, the victim nobody has any right to represent his goods as the goods of somebody else. The what is the problem is already they secure the properties of work, but some people copied their work and utilized without their proper permission from the owner. Then they go to judicial way. That time they give Raja Mudra like this. And the British Trademark Act of 1875 provided formal registration of trademark based on the fulfillment of citation whether the trademark distribution of the goods or trademark or not, trade or not. The registration was considered from evidence of ownership. That's verification by the government judicial and verify and they do not cancel with the previous one. They give trademark. That time they maintain completely one book. That means copy a trademark judicial book from British government. Means what is the early, how to file the patents in early days? But right now, everyone file will go through IP India online.com.in. They'll go. Then before go to digital, some before 90s, 80s, 70s, don't have any digital sector. Then what, how how the particular industries, how many people are planning to file their patents. In this way, early patent system. Here patent means originally meaning open and noun from term letters patent meaning official documents. That means official transparency or open letters. Okay, by the letters patent creating privation, rights, ranking, like titles were conferred by the publicity announced. Here, a patent publication. Here, file form number 18. And the sovereign one who are secure the grant from the sources. The exclusive period is supplying the territory within the certain product. That means India gives the Indian patent, US gives the US releases like USA patent, European covers yearly European European community like 27 countries or 37 countries give the European patent and individually gives UK patent, the Dutch patent, Poland patent like this. And earliest patent system in the ancient Greek cities, Cerebus, leaders destroyed 50, sorry, 510 BC. That the main thing is the sources from European Patent Office publication. Okay, if a cook invents a delicious new dish, this is the entire thing comes under Roman and Greek system. If a cook invents a delicious dish like food, no other cook is to be permitted to prepare that dish for 1 year. Okay. During this time, only the innovator shall reap the commercial profits from his dish. This will motivate to others to hard work and compete in such innovations to encourage the new productivity. That means one thing, and that property that means that delicious dish is belongs to where one, which one, where who are looking and who are created. Already noted. Okay, this is the early patent duration time 1 year. At right now 20 years. Okay, and this is the very complications and features to it. Early English patents was first secured and first granted by English patent from the various sources. Glass matter. The glass matter name is unknown sources glass matter. That glass matters that he could share his technological secret with his apprentice without fear of competition from the other sources. That time, the granted after the verification, Henry IV gave permission and gave the patent rights in 1449. Laterally, the main thing is that English glass matter design in glasses. That glasses granted for making stainless glasses for window of Eton College. That process previously unknown in India. The king commanded that none of his subject could use such arts for a term in 20 years without any consent of job. Okay, here earlier in English churches, in the earlier English churches, Christian churches. There are so many paints also there. This is the glass matter design work. Okay, that work will perfected initially 20 years. Laterally, it was commercialization, publicity. Like after 20 years, if you not renewal, then immediately comes public property. This is the main disadvantage. If you, I have nearly 18 patents rights out of patent grants out of um, 40 patents. In USA one, Indian patent grants, I will tell you, totally 40 patents in my hand. First one, design patents, 3 design patent grants, and 33 Indian patents, and 3 or 4 are secured grants, and the remaining all are publications and publication and examination process also completed. Looking for grant stage, and I'm secured nearly 1 year patent grant along with 130, 180, oh sorry, 196 entries. Patent grants also there. I will show you everything. Please wait. And laterally, the first Italian patent was awarded by the Republic of Florence in 1421 to architect Filippo Bartolus. Was found some difficulty to bringing the heavy stones over the river Arno into Florence of his work of construction massive dam in cathedral in Florence. Like initial the cathedral church, cathedral church, along with some technical design aspects. They give the like what we call, construction design. But initially, and in the Indian days, we are giving that do not give the construction works. But right now, construction works also not giving like intellectual property rights. Okay, so like this. And Veteran Patent, Veteran Patent Act of 1474. The first account of formal patent laws written by 1474 AD when the Senate, Veteran Republic of Italy introduced first patent law. The main aim of their patent is what? Am I audible, sir?
Yes, sir.
Okay.
Yes, sir. Yes, sir.
Okay. The aim of the patent laws was to promote innovations and also secure the protectors from the unauthorized and other sources. Okay. In the way, initially they give 5% of 5% of like what we call Venice is issued about 600 patents during the time 1474 to 1594. But approximately 5% of year of the filing, they give patent rights for the proper examination and judiciary system also they follow. Laterally, if any person file that time, if any person planning to file a patent, before filing the patent, they must prove their work in society. That work will properly utilization in societal way, then move to further. That time they are followed to give the patent rights like this. Invention and incentive and requirement. That can they follow 3 mechanisms. Invention, new to the world. That means no one can create it before. Okay, and incentives to innovative and requirement share knowledge purpose. And everyone knows Galileo Galilei patent rights. Okay, under the Veteran Patent Act of 1744, Galilei Galilei create one object. Everyone knows Galilei creates a telescope. Before telescope, Galilei creates an immense inventor of irrigation, water irrigation, like for agriculture purpose during that time. That means irrigation pump in 1594. His request, the patent coincidence with the theme of modern patent laws. That time, the government, the Roman government, that means Italian government, before following the various factors. But that time, they're categorized into societal need patents and technological need patents and construction based patents and ornaments and all other based patents. Here, we this thing and patent them to Galileo for the patent rates for a device for raising water. Generally, that means irrigation pump. Okay, and UK statutes of monopolies. These are the what they are looking for. The what they are give the opportunity to provide the patents and what are the protected rights and what are the systems they follow. Okay, and the first case of monopolies in between student and guide. Student and guide. First thing, the early landmark case in English law, establishing that a grant of exclusive right of producing any article was improper. That means here, uh, here, student and guide is there. That time, without proper permission from the student, guide was published and officially announced that work belongs to me. In this case, in the case, the uh, student raised his voice during the parliament and that time in societal way, through a judicial way. That time that work belongs to me says from the other sources. That works belongs to me says from the guide. But that guide and student completely dishonor and this case the first thing comes under judiciary manner. Finally, the British government gives the judgment. The Queen Bench Court delivered a judgment for the defendant, resolving that the claims of monopoly was invalid for several reasons under the various factors. Okay, and corporates also history. We right now we are discussing only patents. At right now, corporates in 557, Ireland and the state Columbia were to visit for his former teacher, like the corporate is also there. Laterally, and in the case, and where the this is the state of amendments and India IPR evolution of developments. This is the complete structure, how the IPR works and how IPR judicial system, how IPR courts also there, and how the IPR system interact and how IPR system maintains entire society and how the importance, how we give the importance through our works. Okay, I'm audible, sir.
Yes, sir.
Yes,
Okay.
yes, sir.
Okay. My system is very, my screen is visible, sir. Moving.
Yes, visible, sir, visible.
Okay. What is for a copy? Sir, copy. Sorry, sir. In IPR laws in India, the completely IPR laws administered by the Office of Comptroller Auditor General of Patents, Designs and Trademark. Here, uh, initially, the entire things comes under Government of India. Okay, Government of India gives the statutory body. Here, like so many factors, the Comptroller General of Patents, Design and Trademark Office located in Mumbai. Located in officially Mumbai. Okay, that time uh, there are some regional officers also there. Initially, Government of India gives the Patent Act in 1970 aka amendment. Latterly, the Trademark Act 1999 as amended and Copyright Act 1957 and Design Act 2000 and Geographical Indications of Goods Registration and Production Act 1999. And everyone knows CHIPS, Semiconductor Integrated Circuit Layout, Design Act 2000, early 2000 and entire laws administered by the ministries. Anything like agricultural products and biodiversity products like this comes under Minister of Environment and Forest by the Biological Diversity Act 2002 and Department of Agriculture and Cooperation protected the protection of plant varieties and farmers right act in 2001. This is the IPR evolution of IPR in India milestone from in 1856 to till now. This is the graph where the Indian patent system works and how many patents are we are now in your hand. Okay. In the evaluation of IPR laws in India in 1856 to till now. It is to 2005 and trademarks also, designs also, geographic independence and copyrights and semiconductor integrated circuit design layer also. Okay. Patent post independent development also and patent acts and science feature of the patents. Okay. The object of the patent class from Supreme Court first case. Okay. In 1856, British implemented the first prevent statute in India. The protection of innovations provide certain exclusive privileges to innovators for a 14-year term. Laterally, several importance also there, 1888, 1911, and 1917, 1999, and 2002, and 2005. And trademarks also till 1940 and 59, 58, 99, 2013. And designs also gives some specific acts also. 80, British government, it up to 1911 gives the amendment. Give the different acts also considered as Innovation Design Act and renamed as Indian Patent and Design Act. That means that time Kohinoor diamond, some other valuable things are moved from India. That time the government of British government gives the acts. This is the main disadvantage that time. This time uh, our insect works do not move from the other sources. This is the main thing. And last one, geographical indications. And what is the corporate policies from the UK government and the FINMA 2012 last amendment act? And what is the Semiconductor Act? The Semiconductor Integrated Circuit Layer Design Act was enacted in 2002, which provide and protection for semiconductor IC layer designs. Okay, the patent, post-patent innovation developments, and various acts also there, and the silent period of patents acts. Okay, the industrial design, definition of innovation, so many things, and object of patent class. First case against Supreme Court. Okay, here go through and sir, any doubts? Hello? I'm audible, sir?
Sir, audible. You can continue, sir.
Okay, okay.
Okay. You can continue, sir. No
Okay,
problem.
okay. Okay. In previous class, in previous lecture, we are discussing about all those things like what is the early patent system, what is the patent, what is the design and trademark, geographical indications, semiconductor acts and early patent system and history of and revolution and laws. In this now onwards, we are discussing in detail what is the patent, what is the design, what is the copyrights and trademarks also. And right now, in this session, in this short span of time, we will discuss about the patent, laterally copyright, laterally design, the trademark and geographic indication also. What is the patent? Here, patent occupies a special place in the engineering industry, owing, owing to extreme impact of technology development. They are very important for industry, business, economic growth, and development of a country. This diagram represents the innovation patent, like bulb, Thomas Alva Edison, patent number 438310, patentable date 14 October 1890. Here, patent number is 438 310. Okay, what is patent? A patent is a previously known already we discussed. A patent is a statutory right for innovation granted for a limited period of time up to 20 years from the initial filing date to the patentee by the government in the exchange of full disclosure of his invention for excluding others from making, using, selling, importing the patenting product or process for producing that product for those purpose without his consent. That means if you have any patents in your hand without your proper permission, without your proper non-disclosure agreement between you and the other people, they do not use even. If you are using your product, your idea, that means idea, that case, that completely is punishable offense. Then definition of a patents. Here, Krishna just follow from that. Is also one of the patent rights design. Patent US patent 3, which is the patent right, and secure 1964. A patent is a granted for any device, substance, or method or process which is new, inventive, and useful. Here, patents are generally granted to invention. Inventions include both tangible products as well as process. It is legally enforceable and give the one of the exclusive right to commercial gain, use the invention for the life of the patent. And what can be patented? According to the Indian laws specifies the broad categories of what can be patented as any useful information like the new and non-obvious process, machines, article that is made. It means we are widely using articles, artificial intelligence using artificial intelligence using cancer protection system, artificial intelligence using irrigation system, like this. Without proper like device way and chemical composition, COVID-19 formula and cancer formula, diabetes formula, like this. And that means they are daily used in pharmaceutical. Improvement of any of the above can be patented. Requirements of the patent. An invention must satisfy four basic things. Like, for to be eligible for patent, that invention must be one of the types specified by the state as patentable subject matter. And the invention must be useful for the society. And the invention must be novel, that means original one. The invention must be non-obvious, that means extensional existing. And the term of a patent in Indian patent system. The term of every patent granted is 20 years from the date of filing of the application. However, for application filed under the national phase, under the TCT Act, Patent Cooperation Treaty, the term of patent will be 20 years from the international filing date according to the TCT. If we want to file a international patent from our country, then initially filing Indian patent, then published, then if you want to, that is not, publication is not a matter. If any work, even plagiarized work also published. Okay, that means publication means they ask from the society that works belongs to these people. That works belongs to these people. If anyone objected, publication is not a matter. In my point of view, and there are sources. Publication means objection calls from society and industry. In the publication document, they give classification that works mapping with these number of patents. That time, that patent, who are the classifiers, it belongs to your work. That raises a voice. That time, you are maybe danger. Sure. This is the system. Then, if you want to file a patent to the India to foreign, like any PCT country, then you want to file a Indian patent system, IPR India, alright. Then, once published your work, laterally go through PCT, Patent Cooperation Treaty, through WIPO, World Intellectual Property Organization, WIPO. Okay, which acts govern the patent system in India? All you know that in 1888 to 1970 or 2000 acts. Okay. And does Indian patent gives production in worldwide? No. Why? Because under the TCT Act, within or before expiry, 12 months from the filing date in India, if you are filing provisional application or complete application, then if you want to go examination, publication is not a matter. Publication, if you want to file in the public, if you want to file a patent, then you immediately they give patent number. After that, if you want to if you want to publish early publication, they give, you will have to give another form number 18. But then, if you want to not early publication, for your innovation. Automatically 18 months from filing date to 18 months. They immediately comes under patent Indian Patent Journal. If you want to if you want to your work publicity early, then you want to secure that immediately. Then if you that time you want to plan to file it, plan to pay fees to forms, Form 18 and Form 5. Form 5 for public innovative, Form 18 for publication. Okay, Form 9 for examination. Okay, types of patent. Yeah, types of patent generally can divide into three types: utility patents and plant patents and design patents. Utility patents. Utility patents means that works belongs to novelty-based works, not language works. Maybe it's considered for future technological improvements. And plant patents, that means hybrid patents. That means jam checking and apple combination. And two things plant combination, like create new hybrid trees, hybrid plants, and design patents. Here design patents means everyone knows, like chair also design, here my mouse also design, here water also bottle also design, and my mobile also design, even cover pouch also design, even the main thing, the entire the Gorilla Glass also design comes under design patent. And what is the types of patent application? In the early days, early time, I will show you. Those are categorized into 7 types based on our Indian patent system. Based on their requirement, each country uh, different their own laws. In Indian country, in Indian Patent Office, they categorized into 7 types. First one, provisional application, and second one, non-provisional application. That means complete specification. And conventional application, and PCT, international application, and PCT, national application. And along with application for patent of edition and divisional application. Okay. Everyone knows only provisional application or complete application. Further, no one can idea, I think, convention application, PCT, and PCT national code application, and application for patent of edition, division like this. And utility patent, that means we have three categories, no? Utility patents and plant patents and design patents and utility patents. The utility patent is the most common type of patent that people seek. This type of patents covers process, computation of matters, emissions, and matching the new and useful applications, completely field-based applications, utility-based. The utility patent can also be obtained for new and usable improvements to existing process, composition of matter, and machines and manufacture. And processor refers to any acts or methods of doing something, usually involving industrial and technical process, technological transfer to beneficiary, mutually, like innovator, along with industry and society also. That means societal benefits patents like this and design patents. Here, in recently, Krishna Reddy and me also filing a design patents for agriculture, seed sowing, and what do you tell them? The title seed sowing and pest waste cleaning using artificial intelligence. Okay, in terms of obtaining the design patent, the design is defined as the surface ornaments of object like nagal and which can include shape or configuration of an object. That means Malabar gold have new type of designs and CMR gold have new type of designs And every armament company creates own designs. Immediately, the designs comes under secure, then it will come publicity. Okay, I will show you everything. Please wait. And plant patent. A plant patent can be obtained to protect a new and destructive plants. That means combination creates a combination of new product. That means can reproduce to existing plants or create a new hybrid like this. And patent administrations in India. In Office of the Comptroller General of Patents and Designs and Administration in the Patent Act 1970 and form the rules, and everything comes under CGPTM. Any reference of the government, central government in act or rules referred to the government, typically represented by the secretary in the Department of Commerce and Industry, laterally called as the Department of literally Minister of External and Minister of Industrial and Promotion Policy levels. The Office of the Comptroller General of Patents and Designs also responsible for the administration of patents, designs, and trademarks and geographical indications and semiconductor designs also. The Ministry of Industrial Promotion, Industrial Policy and Promotion through anti-mapping mechanism, Joint Secretary, the corrective and supervisory over control of the CG, CGPD, TM, and all those things. And where initially, where the EIP India's IP laws are introduced in 1970, laterally, various factors April 1, last 1978, the last acting amendment, and so many amendments also there based on technical requirements also for the nation and patents, patent class. In patent class, the patent class completely handled by very strict way. So many people think like that author positions and 2000, sorry to say this word, as as an innovator, I want to tell something as a responsible way. So many people feel like that I have 3 patents per year and go through and go through commercial, go through in channelized like like other consultancy way. They offer positions. It is not good for your your health also, wealth also. Why? Because they are maintained a very good manner. They are maintained uh, original good. They maintain novelty work is good. No one can, no one can only. That means money from society, other people. At time, BTech or MTech or many other projects already published works papers also, SEA papers and Scopus paper books also come into patent right, patent object, patent object documentation. This is the very dangerous situation. If we have SEA paper in your hand, that SEA paper planning to file patent, it is good. Government also gives the opportunity to file. Within 1 year, you are like your inventable SCA paper work planning to file a innovation like utility patent. That time the publicity, the then corporates issues also not there, and that means publisher along with editor also responsible for your work. Why? Because your work completed novelty, that they have only rights, only publication rights, but entirely works belongs to you only. That thing, your work will That work, that time the work will plan to file a patent. It is the MNC way. Okay. I'm audible? So tell me, I'm audible?
Yes, sir. Yes, sir. Yes.
Okay. What is the patent law? Here, patent law is some judicial system also there in criminal law and normal law. That means normal law, like particular not and the patent law. The patent term also known as utility patents with 17 years. But the design patents is 14 years from the date of present issue. First, to invent in the building and testing of innovative that means examination, patent examination policy. The Act of Parliament preparing and filing patent application also considered for reduction of practice. Okay, and disclosure as to invent rate of innovation. Okay, and first thing is length of patent production, how many years? Second one, rate of invention. Third one, disclosing document program. That means before going to the patent filing, you and your idea who are go through filing. In the way, so many WhatsApp groups are there trying to find patent author one, author two, author three, and author four. But no one can disclose you and the consistency taken any non-disclosure agreement, NDA. That means the NDA being that time if any classifications are mapping, that means any works belongs to previous industry. I think you know 90% of patents comes under industry. Okay, that time your work belongs to mapping any other works like industry or any other people, industry people in that case. Then go through, then they show what is your non-disclosure. Here is the non-disclosure agreement. One, first one, finish. Your entire period gone. Immediately, the consultancy people switch off and immediately your comes under picture. One more thing. One innovator is belongs to that country. One innovator belongs to that area. One innovator belongs to that area. But that particular Patent Right Act is Objective 7A. The main thing is the property belongs to which one that must be identified or origin or region must be reason by Indian government's region is responsible for everything. Okay, this is the main thing. Object 7, class 7. Okay, this is the main thing. And patent claims. If you are mapping anything, do not ask even question also. There comes under picturization, like commercial picturization. Until uh, until like your patent filed and published in 2019, I think 2020. But your patent without examination, they are maintained publicity, maybe examination purpose. Before like what we call patent publication. That time they asked till now 2019 or 20 or 21 to till now, how much revenue you will generate it based on my work through your filing. That time, how much amount they claim from your end, no one can support. Even Indian judicial system also not supported. This is the main thing. Okay, then before going to the filing mechanism, first clear idea about this mechanism. Even consultancy people also not there. They want money. But the once you file your patent in your name, complete in your name and institution, especially. Some people are belongs to this time. I am working in some college. You are working in some college. That time, the institution your name your belongs to that institution. That institution may be responsible for your innovation. Why? Because your belongs to that institution. Your belongs to individual. Then individual means comes under you only. That means that means your work not belongs to institution, comes under you. That institution comes belongs to you, that automatically picture comes institution. Institution is the responsible for everything. This is the first thing. Then I suggest you, before going to the publication, before going to the filing, then go through novelty and original work along with, do not do the similarity works. This is the main thing. And patent titles and doctrine of equivalence. Okay. And patent order, economical right also there. And top 10 company, top 10 patented companies in 2020. Okay. This year, the Samsung, Electronic International Business Machine Group, IBM, and Canon, Microsoft, and Robert Bosch, Panasonic, LG, and General Electric, Intel Corporation, and Siemens. In 2022, most of the patents in Samsung, along with Apple also, Google too. And thank you. Then we are planning to go another slide.
Hello, Krishna Reddy.
Hello, sir. This is sir.
Hands on ఉంది సార్.
Okay. Hands on,
Sir.
okay.
Sir,
Sir, Bosubabu sir, tell me, sir.
sir, sir, this is the my innovation patent.
Okay, sir. These are all.
Please, see, this is the international patent. Okay, comes under all those things. Virtual brain cloning and telepathic data communication with virtual reality, holography. Visible, sir?
Visible, sir.
This is the WIPO, World Intellectual Property Organization to Patent Cooperation Treaty. This is the patent application number, international application number. This is the documentation, field of invention, and the background of the invention, and this is the PCT number. This is the publication number. Okay. And summary of invention and brief description of drawings and detailed description of invention and algorithmic approach and what we are planning for innovation compared to previous one and novelty like this. Plans. And diagrams where you works, how to works. And it is 64. Okay, this one, and I will show you another one. This is my innovation, intellectually Indian. means Internet Protocol version 16. I am the innovator of the IPv16. Okay. After IPv4 and V6. Okay. That means drafting work, field of invention. These are all those things are common in the national fields and in the international fields. Invention, field of invention, and background of the invention, and background of the invention, and objective of the invention, the side endings along with your working in particular way, and summary of invention, and brief description of drawings about works, where it is used, how to works and how to implement it, and detailed description of invention and industrial applicability, advantage of invention, and solution to the problem, and a technical problem like this, and what are the claims invented compared to IPv4 and V6. What is the new thing I'm invented? As a first person, new level. This diagram at IPv16 datagram format. Okay. Source and destination, where it is useful and how data communication transformation for everything. And here right now we have only class E only. And invented F, G, H, and I up to 1024. Here, 255 only. And invented up to 1024 is the final in computer vision system. Okay, I'm giving the last and up to mark. If no one can, I think, any further innovation, yet under me only, under my innovation, when the word is used, IP classification mechanism and IPv16 architecture, like where it is useful like this. And this is the 6 report. Okay, then we are go to the copyrights. Here, copyrights. What is the copyrights? Sir, understood, sir, about patent system? Am I audible, sir? Hello?
Yes, sir.
Okay.
Audible,
You
sir.
have the yes, sir. Thank you. Any doubts regarding patent filing, patent drafting, the field of invention to claiming and diagrams like this. Okay, this is the structure to work the documentation, like specification. Okay, along with what is the status, you know that under the settings and the complete specifications. Please unmute yourself, madam, please. Madam, please unmute yourself, please. Okay, thank you. Second one, copyright production. From beginning. Initially, you have idea about just what is the you everyone knows about copyright term already. But what is the copyright? Here, copyright is the very dangerous one, I think. Even patent also we are planning to escape, I think. But the copyright we are not avoided because these laws are very strict. Okay. Copyright law protects original works of authorship, fixed in any tangible medium of expressions to meet the standard of the original required under the policy copyright law. Here, an author need only demonstrated a modest degree of intellectual labor. Here, your work is fixed when it is embedded in a tangible form that is presentable by the human sense. Okay. Here, what is the definition of the copyright? Copyright is a legal term describing the rights given to creates for their literacy and artistic works. Okay. Here, copyrights are set of exclusive rights granted by law to the creators, authors, and producers of forms of creative expressions such as literacy, musical, and cinematographic graphics. Cinema, before going to the cinema, one ad is there. Central Board of uh, Film Certification, like this. Certificate, Central Board of Film, and National Copyright, it's Paris Convention Treaty and Barnet Convention Treaty and Rome Convention, Geneva Convention, and Business Brussels Convention, and WIPO Copyright Treaty also. Here, every convention gives the right to right to from right to manage from other unauthorized sources. And you know that the diagram represents what we are looking, what we are secure from other sources to the copyright. Copyright works that can be copyright literacy works like algorithms, books, your papers, research papers. Everyone knows what your research works will be. Sorry, that works. Your work belongs to you only. Okay, that means the publisher have only publicity rights. Innovators have that means corporates completely belongs to you only. That time we are publishing we are planning to publish your article through corporate through conferences. That conferences up to final stage. You are giving corporate form from your end. That means no objection to publish my work in the conference through publisher platform. This is the corporate form menu. Okay, that means literacy work, authorship, and book writing, everything literacy comes under literacy work. Music, music system, complete comes under this. And artistic, that means design like any dramatic, that means any design drops like this, like Tom and Jerry and Pomba, Teman and Pomba, and animation like works, animation works. Most of the corporate works below, most of the corporates have Disney, Disney land and dramatic man's like this recording. Okay, and subjective matter of copyright. Here, the 10 enumerated categories are follows. First one, literacy works, okay, musical works, and dramatic works, and cinematographic works, and photomics, and pictorial, and graphics, and sculptural works. Here, one thing, pictorial means professional photographers, cover page photographers, like professional photographers, wild photographers. That means they take pictures and selling through the copyright. Professional photographers earn money through the copyright policy. And graphics. Graphics industry also works like this. And motion pictures, movies like this. And audio visual works and sound recordings and architectural works like construction based works. Okay, subject matter first one copyright. First one we discussing literacy works. J.K. Rowling, who are the writer Harry Potter series. Literacy works like this is the best example. You are also author, no? Like filing your book, so many platforms like Amazon and many other platforms. And right now, I hear one news. The students are also publishing a book, I think, today or yesterday. That means they have Harry Potter, they have like, literacy work, privately or like anything. It is one of
I will be
expressed
sure.
IoT, very good sir. Congratulations. It is one of expressed in words, numbers, or other verbal or numerical symbols regarding of the nature of the material objects such as books, periodicals, manuscripts. Here, manuscript means we are writing research papers, generally called as manuscripts, not research papers. Everything comes under manuscripts. Even how many types of research papers are there? Nearly 36 types of research papers are there. Even literature works and comparative works and the survey works, case study and original work and novelty based works. This time completely 36 types of research papers are there. But everyone, very few people are there. Like his works, his original work, editorial work, and editorial work, editorial paper, and survey paper, literacy paper, and review paper, and finally research paper. Everyone knows this. But based on research environment, 36 types of research papers also there. Okay. And phono records, films, and tapes, discs are cards in which they are embedded in physical form. Okay. In digital form comes under copyright also. But where we are planning to publish in physical of your work, then comes under literacy. Okay. That here the book belongs to you, the books belongs to who are wrote. It means the literacy work belongs to author or any editor like this. But publicity rights belongs to only publisher. Okay, you and author and publisher have a strong agreement between or royalty and commercialization rate. How many books are initially releases and how much royalty will earn based on selling. Okay, in the productive way, in the productive way, in conferences, comes under volume one, volume three, and volume four like this. If any conference you're conducting, your papers comes under book chapters and book publishing and book series or any other as a conference papers. But the conference have own writing one people, handle one people. That means conference organizer and program chair. Here, program chair handle all those things like program operations. Here, organizing chair means handle and responsible for entire process. Conference initial day to end of the publication. After that, during the publication book, if any work matches, if any work similarity with any other one, he is the solo responsible for corporate issues. This is the danger thing. Okay, here you are signed corporate form sent to along with your original paper. That paper and signed work corporate form that your work is finished. Later it may be transferred to editor. The either along six plagiarism policies, similar 20%. I think if we have any further any mismatches like this, any applications are not done by your end, maybe plagiarism below 20 is safe now, at any case. Except, sorry, include references. Maybe references are excluded. The 15 maybe plagiarism is good for publication. Here, 8 is the solo responsibility for your book. Okay, you are not responsible for your publication. Why? Because you are the responsible for only publication paper. Okay, and musical works. Everyone knows, including academician words also. Musical composition may be the terms of noted copies, such as phonographic records and bells and dramatic works also, including accompanying music background. It is usually a theatrical performance or plays a performed for stage, movie, television, and radio. That means every serial has subjective works. Like if you see like this, see the drama company and any serial and movie, one term is there. This work is what we call like ఇది కేవలం కల్పితాలు మాత్రమే, ఎవరిని ఉద్దేశించింది కాదు, ఎవరిని ఉద్దేశపూర్వకంగా బాధ పెట్టింది కాదు, ఏ జంతువుని కూడా దీంట్లో ఇన్వాల్వ్ చేయలేదు. మేము కేవలం వినోదం మాత్రమే దీన్ని మనం చూపిస్తున్నాం తప్ప ఎవరిని కించపరచలేదు అని చెప్తారు. ఎందుకు? దట్ మీన్స్ దట్ థింగ్ are subjective under Copyright Act. Without these things, immediately comes under Copyright Act. Even you know this. Even YouTube also taken many videos from our end. They are not mentioned. But when you have YouTube channel, that time you want to upload your video. That thing before going to the upload video, everything scanned. The layer by layer image filtering, AI image filtering techniques mapped. Is there anything mapped with previous existing content in worldwide database? Not only YouTube, not only Google, like this. Entire world database. Then, if any copyright issues are not done during the YouTube video transmission section, that will gives approval for publication. That will approval for post like publicity like comes under YouTube video. Otherwise, this is the plagiarized content. Please remove from your end. Automatically blocked. Okay. Then one more thing. Many people are your work published in lab back publication and any other self promoted self self book publishing. Then they are encouraging initially for your work will be published in lab back publication and other platforms maybe, but they will consider 30 to 30 to 6 30 to nearly 1 year, maximum 1 year. They will show or give the ISBN number, everything. During the time, if any works mapping with another database, immediately they transform your works belongs to the people automatically mapping. That time, if anyone mapping your work belongs to that people, then raise a case. Otherwise, the work will continuously show up in databases. And phononyms, that means names. Phononyms are generally photo mime. They are mime is a performance using gesture expressions to communicate with no accompanishing sound. Like trademarks like this, Joker images like this, and dance shows us like choreographic works like Chiranjeevi Vienna step is there, na? That work belongs to Lawrence Master. Okay, along with most of the works who are performing, who are contributing in dance performance, act, and choreographic works. Most of them, like Michael Jackson, entire his stage recording comes under cinematographic works, like corporate works. If you are using any works belongs to other people, dance masters, and they show many things, then immediately there is a corporate act. Here, Srinagar Drama Company, D show, maintained like choreographic works. This choreographic works completely here. So many dance masters are there, but no one can claim it works belongs to me only. Why? Because they are paying salaries for their work. Okay, that means the entire video comes under ETV bill. ETV means belongs to Ramojana sir. Okay, this is the productive and entertainments like this company based entertainments. And another one, pictorial and graphic and sculptural works. In this images, Alami, these images were there, na? Buffalo, above Alami. Above means Alami. Yes, see like this. This actually this picture belongs to which one? Alami company. If they are not used properly without their permission, then immediately came. Here it came, corporate came. Okay, corporate policy came. Okay, corporate act also there. Here, and if you want to find, if you want to picture taken from your mobile, this is original. Why? Because that work not mapped with any single other objects. Why? Because these are newly created by your device. Okay, another one. This time, right picture. This is the image represents various things. But if you want to check whether it is operated image or not, then go through type anything in Google Images. Then open Google any images. Before that, maybe this image may be copyright policy. So maybe you taken permission from subject to owner like this. Please check it yourself. And motion pictures. Motion pictures is a audio visual works like videos, audio video works, and of series of written images that when shown in succession parts and impression of motion together which accompanies sounds like motion pictures and DC and many studios are created movies like Superman movies, any other publicity movies. Like if any movie comes only not producer, please check it yourself. That movie comes under one company. The company provides Leica, Allu Aravind provides Geta Arts, and Vijayanti Movies Arts. This is the company. The company promote through one who are belongs to that works that means who are secured Central Board of Film Accreditation certificate. These are belongs to this one. These are belongs to which works and corporate belongs to this one. If anyone duplicate itself and without their proper permission from the thing, those who are owners, then immediately they raised a voice. They want to claim royalty for their works. Okay, next one. Audio visual works. It is everyone created on motion pictures like some subjective works like this. And audio video visual works is work consisting of a series of printed images that are intended to be shown in the use of machines or devices such as projectors, viewers, and electronic equipment together with accompanying sound. Like in during the any festival in your college, then video recording is there, no? YouTube live show and YouTube live recording, which comes under Copyright Act. The Copyright Act belongs to your institution. Okay, if anyone not used this video and cutting in the video, that that means uh, the property belongs to you only. And sound recording, DJ sound, anything that works belongs to Gangnam style, that belongs to that people, and coloring that belongs to Dhanush, and so many. Even music directors also initially go to the music in audio function. Like everything pre-planned, no one can copy their work. In movie, first one copyright policy, copyright certificate is there, and any movie during the movie artist and producer along with company, they they comes under agreement. That means copyright agreement. First one. That means second one remuneration agreement. This is the civil law. And third one, subjective artist work and in the sets comes under artistic works. Please check it if the work belongs to Bahubali and good movie. Bahubali is good movie. They have too many uh, too many sets are there. Why you are not using the same sets in other fields? Because the copyright. Okay, in every movie, one in dance video, in song, one set is different and another set also different. Same movie also, they do not use the same set, but because already they are using in previous set. One more thing. One movie team is go to uh, like Niagara Jalpatam and Niagara Forest and doing the recording. Okay, song is completed and uploaded. And another movie team is can go to Niagara Jalpatam, Niagara Forest and take it and there. Here, fixed background is nature. Okay, the moving object is humans and anything. Here, fixed object is not considered for copyright and any rights, but because these are universal properties. Okay, one more thing. Here, insurance policy also there. Here, company is fixed. Here also fixed. You are not fixed, but because you are experimental. You are expert object. That means they give are subjective to the productivity tendencies like this. And architectural works. Construction work is not considered for patent or designs, but the construction work, that means architecture work. That's that means system architecture, like design architect, like building plan design comes under carpenter. But because that only that builder wants to build this kind of image, this kind of building based on designs. Okay, the designs designed by designer from the certified designer. The certified designer from the government institution, Jawaharlal Nehru Architecture, uh, University of Architecture from Hyderabad, and any IIT department of designs also there. They give they produce like our student, they produce like doctors. They give designs. Okay, in buildings and roads. Roads also comes under design works and um, like designing and parliament like this. Initially, the parliament also comes under the copyright and this is the copyright for principles of corporate law. So the first one, the laws for the owner of rights, original scope of right, and expanded scope of right. And test for determine copyright and public domain works. Here, for public domain works, go to what is the law for owner rights? It, the act gives the owner of the copyright the exclusive right to do and authorize others to certain things in recording copyrighted works, including copies, distributed the work, display or content to work publicity, and to create descriptive works. And original scope of copyright. The act applies to nearly all forms of capture and permanent, okay, including works such as books, photographs, architectural drawings, music and drama, and sculptures. And expanding scope of copyright. That means the copyright laws have adapted to advancing technologies like developing things like videos, motion pictures, electronic media, and even social media also different. Electronic media and software, multimedia works and databases. And test by determinant copyrights in fixed any tangible medium of expressions, such as captured in an accessible from the content. And what is the public domain works? If the works published from 1920 to 1978, they are protected for 95 years from the publication date. If the proper copyright formalities were followed, since 1978, works generally have copyright protection for life per author plus 70 years from the 89 to till now. It should be reduced for 60 years. That means copyrighted who are the author of the book, author of the work. That means 60 or 75 years or whole life. It's covered. If they want to extend their uh, rights, then give the authorized person. Okay, what belongs to blood relations and other nominated people. And if no expressions, if no exceptions seek permissions from, if anything mapped from other sources from the one of the copy, they give face-to-face treatment exceptions. And penalties. The penalty also we are not identified. We are not expected how much penalties are they given through the IPR laws. Okay, it is completely civil as well as criminal punishment. If there so many people have taken from authorship to the initiation, then author belongs to initiation. If the work is not genuine, then immediately the works not genuine, then immediately comes under picture institute, not author, not innovator. This is the best thing for any. Is the best example of damage like this. And this is my copyright grant from this one. My works, Internet Protocol version 60 from government of US government. Okay. This is the same work secured from the Indian Copyright Act, Indian Copyright for Internet Protocol version 60. Okay. Thank you. Next, we will go through another topic. Any doubts in copyrights? Hello? Hello, I'm
No
audible,
problem.
sir?
No problem. No problem. Audible. Carry on, sir.
Only one raised a question, sir. Who is raised questions? Any doubts is there?
N. Ramesh is raising the question. Hello,
Yes,
Ramesh.
sir.
You can ask the question. Ramesh?
Madam, please unmute yourself, please.
Ramesh,
Madam, please unmute yourself. Madam, please unmute yourself. Hello, who is this?
Ramesh. Hello, Ramesh. Is not. You can carry on, sir.
Sir, one more thing. Some disturbance is there, sir.
Disturbance. Who is the?
ఎవరో మాట్లాడుతున్నారు సార్ కంటిన్యూట్ గా లేడీస్.
ఎవరు అన్మ్యూట్ చేశారు సార్?
సార్ ప్లీజ్ ఆస్క్ మీరు గట్టి ప్లీజ్ ఆస్క్ సార్. చెప్పండి మీకేం కావాలి.
రమేష్ సార్,
సార్ ప్లీజ్ ఆస్క్ సార్. మీరు గట్టి
నీరుగొట్టి రమేష్.
రమేష్ సార్ అడగండి.
సార్ అన్మ్యూట్ యువర్ సెల్ఫ్. రమేష్ సార్ అన్మ్యూట్ యువర్ సెల్ఫ్ and you can ask.
Yes, sir. Sir, good afternoon, sir. Myself, I am Ramesh.
సార్ థ్యాంక్ యూ సార్. చెప్పండి.
Sir, I have one doubt, sir. Suppose
Yes,
I am already published one paper in particular
Which paper?
organization. Yeah, my paper is a research paper, sir. I am published.
Yes, yes.
If I am going to get it the patent, but that credit goes to wherever I am working in the institute or my personal. That is my doubt, sir.
Yes, sir. It is clearly, I will clarify everything. Please listen carefully. మీరు ఏం చేస్తారంటే ఇది ఆర్ యూ తెలుగు పీపుల్?
Yes, sir. Telugu, sir.
ఓకే, మీకు అదే రాసి చెప్తాను సార్. మీరు ప్రీవియస్ కాలేజీలో కానీ లాస్ట్ దీంట్లో టైం పీరియడ్ ఉంటుందండి. మీరు ఫైల్ చేసిన మీరు పబ్లిష్ చేసిన వర్క్ నావల్టీ వర్క్ అయ్యండి, అది ఎస్సీలో కానీ స్టాపర్స్ కానీ పబ్లిష్ అయ్యండి. ఆ వర్క్స్ ని విత్ ఇన్ 1 year లో ఆ టైంని మీరు దాన్ని నావల్టీలో చూపించుకొని ఆ వర్క్స్ ని మీరు పేటెంట్ ఫైల్ చేసుకోవచ్చు సార్. విత్ ఇన్ వన్ ఇయర్ ఎందుకంటే
Thank you, sir.
1 year
Within one year
లో మీరు ఫైల్ చేసుకోవచ్చు. ఎందుకంటే కార్పొరేట్స్ అనేవి 1 year తర్వాతనే దాన్ని ఎంబ్రిగో పీరియడ్ అంటారు. 2 years అండి. 2 years వరకు వాడు ఏం పేపర్ అనుకోండి పేపర్ అమ్ముకోవచ్చు. 2 years తర్వాత వాడు మార్కెట్ లోకి లైసెన్స్ వస్తాడు ఓపెన్. అలాగా మీకు విత్ ఇన్ 1 year వరకు కూడా ఆ వర్క్స్ పైన వాడికి ఎటువంటి ఎంత కార్పొరేట్ మనం సైన్ చేస్తాం కదా డాక్యుమెంట్, కార్పొరేట్ ఫార్మ్స్ దాంట్లో రాసుకుంటాం మనం ఎవరైనా చదవం అసలు. 1 year
ఇప్పుడు కరస్పాండింగ్ ఆథర్ ఒకరు సార్, నేను సెకండ్ ఆథర్. ఇప్పుడు నేను పేటెంట్ రైట్స్ కి అప్లై చేసుకుంటే
చేసుకోవచ్చు, కానీ మీరు అతని నుండి పర్మిషన్ తీసుకోవాలి.
ఓకే సార్.
ఎక్కడంటే లాస్ట్ లో ఒక పేపర్ రాసినప్పుడు మీ అందరికి కూడా ఒక డైలాగ్ ఉంటది, ఇతని కాన్ఫ్లిక్ట్ ఆఫ్ ఇంట్రెస్ట్ ఉంటది. ఆ కాన్ఫ్లిక్ట్ ఆఫ్ ఇంట్రెస్ట్ ఏం రాసి ఉంటామంటే authors don't have any conflict of interest during the work and రాస్తారు.
నేను అడ్డించట్ల కాలేజీ నుంచి వచ్చేస్తాను దగ్గర.
Mr. Sir, please unmute yourself, please.
లీవ్ ఏం పెట్టాను, 3:30 నుంచి బయలుదేరి వచ్చేస్తాను.
Mr. Sir, please unmute yourself, please.
పర్మిషన్ పెట్టి
కృష్ణారెడ్డి అన్మ్యూట్ చేయమ్మా.
సార్ మీకు అర్థమైందని చెప్పింది.
అర్థమైంది సార్, అర్థమైంది.
ఇప్పుడు అదే వర్క్ ని సమ్ యాడింగ్ చేసుకోవచ్చు. ఇప్పుడు మీరు 2010 లో కానీ 13 లో వర్క్ చేశారు సార్, ఆ వర్క్ లో మీకు నాలెడ్జ్ ఉంది, ఆ వర్క్ నావల్టీ వర్క్ అని మీరు ఫీల్ అవుతున్నారు. కాకపోతే ఆల్రెడీ ఆ వర్క్ ని మీరు ఏం చేశారంటే కార్పొరేట్స్ తోని అతనికి ఇచ్చారు. ఇది మీరు అతనికి ఇచ్చారు, ఎవరికి కంపెనీకి ఇచ్చారు. ఎందుకు అది 1 year అయిపోయింది. ఈ 1 year లో మీరు ఏం చేస్తారంటే అక్కడ అడుగుతారు డెక్లరేషన్ ఎవ్రీ పేపర్ బ్యాక్ సైడ్ కూడా నార్మల్ జనరల్ అయితే పెద్దగా పట్టించుకోరు, కానీ కొన్ని స్టాండర్డ్ కంపెనీస్ అనుకోండి ఏం చేస్తారు, మీకు డెక్లరేషన్ అడుగుతుంది, ఫండింగ్ డెక్లరేషన్ అండ్ ఇంట్రెస్ట్, కాన్ఫ్లిక్ట్ ఆఫ్ ఇంట్రెస్ట్ అండ్ వర్క్ ప్రోగ్రెస్ అడుగుతాడు. మీకు అర్థమైందా?
అర్థమైంది.
అక్కడ క్లియర్లీ అంటే మీ మధ్యన ఎవరి మధ్యన కాన్ఫ్లిక్ట్ ఆఫ్ ఇంట్రెస్ట్ లేకపోతే పర్లేదు. ఒకళ్ళు ఉందనుకోండి, ఆ వర్క్ ఆ వర్క్ కూడా చేయడు, అప్పుడు ఏమడుగుతాడు,
ఆహా.
ఈ వర్క్ ఎవరెవరు ఎంత వర్క్ చేశారు అంటే
ఓకే.
మీకు అర్థమైందా? ఈ పబ్లికేషన్
అర్థమైంది
వర్క్,
సార్.
ఈ నావల్టీ వర్క్ ఒకరు చేశారు, డాక్యుమెంటేషన్ వర్క్
ఓకే.
ఒకరు చేశారు, అండ్ డిజైనింగ్ వర్క్ ఒకరు చేశారు. అక్కడ పర్టికులర్ గా మీ వర్క్ ఇంప్లిమెంటేషన్ అనుకోండి, ఆ ఇంప్లిమెంటేషన్ వర్క్ లో మీకు రైట్స్ ఉంటాయి.
అవును సార్,
ఆ వర్క్ ని
కాంట్రిబ్యూషన్
మీరు
అంటే వాళ్ళ కాంట్రిబ్యూషన్. ఎస్ సార్.
కంట్రిబ్యూషన్ అంటే క్లియర్లీ మెన్షన్ చేయమంటారు అక్కడ.
ఎస్ సార్.
ఆ కంట్రిబ్యూషన్ గా మీరు తీసుకొని ఆ కంట్రిబ్యూషన్ ని మీరు ఫర్దర్ గా కొద్దిగా నావల్టీ యాడ్ చేసి ఫర్దర్ గా మీరు పేటెంట్ చేసుకోవచ్చు.
ఓకే సార్.
అర్థమైందా?
ఐ గాట్ ఇట్ సార్.
ఓకే సార్, లెట్ మీ గో ఫర్దర్.
థ్యాంక్ యూ సార్.
బోసుబాబు సార్, పబ్లిష్ అయిన
Yes, sir.
తర్వాత గ్రాంట్కి వెళ్ళడానికి ఎంత టైం తీసుకుంటుంది?
సార్ ఇప్పుడు మీకు నేను క్లియర్ కట్ గా ఇన్ఫర్మేషన్ ఇస్తాను, జాగ్రత్త ఇవ్వనండి. మనము ఈ రోజు జనవరి 1, 2023లో మనం పేటెంట్ ఫైల్ చేసాం సార్. మీరు అది కానీ ఎర్లీ దాన్ని ఫామ్ 1 అంటారు. ఫామ్ 1లో కానీ మీరు అంత ఎంతమంది ఆథర్స్ ఉంటారు, ఎక్కువ ఆథర్స్ ఉన్నా వేస్ట్. దాంట్లో ఆథర్స్ లో ఒకరున్నా 10 మంది ఉన్నా 50 మంది ఉన్నా అది అందరికి ఈక్వల్ ప్రయారిటీ. ఆథర్ లాగా మన పేటెంట్ పేపర్స్ లాగా ఫస్ట్ ఆథర్, సెకండ్ ఆథర్ కి, థర్డ్ ఆథర్ కి డివైడ్ అయిపోతుంది. కానీ పేటెంట్ వచ్చేసరికి ఇన్నోవేటర్స్ అందరికి ఈక్వల్ ప్రయారిటీ ఇచ్చింది గవర్నమెంట్. ఓకే, ఫస్ట్. ఇప్పుడు మీరు ఫైల్ చేసిన తర్వాత మీరు పబ్లికేషన్ కి ఎర్లీ పబ్లికేషన్కి వెళ్ళలేదనుకోండి, ఫామ్ నెంబర్ 18 అని ఒక ఫామ్ చేయాలి. దానికి ఎర్లీ పబ్లికేషన్ కి 2500 కట్టాలి. అదే ఫామ్ నెంబర్ 16 కి 1600 కట్టాల్సి ఉంటుంది. ఓకే, 1600 కట్టేసి మీరు కంప్యూటర్ స్పెసిఫికేషన్కి వెళ్ళలేదనుకోండి, ప్రైవేట్ స్పెసిఫికేషన్కి వెళ్తే మీకు నెంబర్ జనరేట్ అవుతుంది. ఎంతవరకు? అది సంవత్సరం రోజుల వరకే వ్యాలిడిటీ ఉంటుంది. దాని తర్వాత అది అబార్ట్ అయిపోతుంది, నెంబర్ క్యాన్సిల్ అయిపోతుంది. అంటే ఆ వర్క్ కానీ ఆ నెంబర్తో కానీ మీకు ఎటువంటి సంబంధం లేదు. ఓకే, అది పోయినట్లెక్క. ఒకవేళ ఆ వర్క్ మీరు ఎక్స్టెండ్ చేసుకుంటారండి కంప్లీట్ స్పెసిఫికేషన్స్, ఆ నెంబర్ కంటిన్యూ అవుద్ది. ఓకే, అదే మీరు డైరెక్ట్ గా కంప్లీట్ స్పెసిఫికేషన్ లేదనుకోండి, మీరు జనవరి 1, 2023లో వెళ్తే మీరు ఎగ్జామినేషన్ కి అంటే మీరు ఎర్లీ పబ్లికేషన్ కి వెళ్ళలేదు, 2015, 2500 రూపీస్ కట్టకుండా మీరు ఓన్లీ 1600 కడితే మీ నెంబర్ జనరేట్ అవుతుంది, టైటిల్ కనబడుతుంది. మీరు ఎర్లీ పబ్లికేషన్కి వెళ్ళకపోయినా సరే ఎంతవరకు 18 నెలల తర్వాత 18 months తర్వాత గవర్నమెంట్ అనేది ఆటోమేటిక్ గా దాన్ని పబ్లిష్ చేస్తుంది. ఇది పెరిగిన జనరల్ లో అబ్జెక్షన్ చేస్తుంది. అక్కడికి పబ్లిష్ అయిన తర్వాత మళ్ళీ 18 months పీరియడ్ ఉంటుంది, ఎంబీగా పీరియడ్. ఆ 18 months లో కానీ మీరు కానీ ఎగ్జామినేషన్కి వెళ్ళలేదు అనుకోండి, ఎగ్జామినేషన్కి వెళ్ళకపోతే ఆ కంప్లీట్ గా ఆ పేటెంట్ అనేది, ఆ అప్లికేషన్, పేటెంట్స్, దట్ వర్క్స్ ఎవరైతే ఇన్వాల్వ్ అయినారో ఆ అందరూ కూడా ఆ వర్క్ కి ఎటువంటి సంబంధం లేదని గవర్నమెంట్ ఆఫ్ ఇండియా రిలీజ్ ఇచ్చేస్తుంది అబౌట్. మోస్ట్ ఆఫ్ ద పేటెంట్స్ కి మనం చాలా మంది గమనించాము, టీచింగ్ ఫీల్డ్ ఉన్న వాళ్ళని. వాళ్ళు ఏం చేస్తారంటే 2018లోనో 2015లోనో పేటెంట్స్ కి ఆథర్ ఫార్మ్స్ అవి ఇవి పెట్టేస్తారు, పబ్లిష్ చేస్తారు, వదిలేస్తారు. దాని ఏమవుతుంది, వీళ్ళందరూ నెంబర్స్ చూపించుకుంటారు. ఎన్బిఏ నాక్ వెరిఫికేషన్ అవుతుంది. వెరిఫికేషన్ అయినప్పుడు వాళ్ళు చెక్ చేసినప్పుడు అదే అబౌట్ ద అప్లికేషన్ ఉంటుంది. అంటే నెంబరు సెర్చ్, అంటే సెర్చ్ లో ఉండాలి, అప్లికేషన్ సెర్చ్ అది కాక చూపిస్తాను. సెర్చ్ చేసినప్పుడు కూడా అది నెంబర్ ఉండదు, ఆథర్స్ ఉంటుంది. ఫస్ట్ లో మాత్రంకి ఫైల్ చేసిన వెంటనే ఓపెన్ అవుతాయి, పబ్లిష్ అయ్యి ఓపెన్ అవుతాయి. కానీ డ్యూరింగ్ ద టైంలో కానీ మీరు ఎగ్జామినేషన్కి వెళ్ళకపోతే ఏమవుతుంది, 18 months తర్వాత ఆటోమేటిక్గా అది పోతుంది అన్నమాట. దీంట్లో చాలా మంది కూడా మనం రెజ్యూమ్ లో చూపించుకుంటాం, ఎగ్జామినేషన్కి వెళ్ళిన పేటెంట్స్ చాలా వరకు ఫెయిల్ అవ్వదు, మోస్ట్లీ ఫెయిల్ అవ్వదు. అంటే పబ్లికేషన్ తర్వాత 18 months వరకే దాని వ్యాలిడిటీ. ఓకే, మీరు ఎర్లీ పబ్లికేషన్కి వెళ్ళినా 18 months, ఎర్లీ పబ్లికేషన్కి వెళ్ళకపోయినా 18 months. ఎర్లీ పబ్లికేషన్కి వెళ్తే 18 months వ్యాలిడిటీ ఉంటుంది. దాని తర్వాత ఎగ్జామినేషన్కి వెళ్ళాలి. ఒకవేళ మీరు ఫైలింగ్ చేస్తున్నప్పుడే ఎర్లీ పబ్లికేషన్ ఎలాంగ్ విత్ పబ్లికేషన్, ఫైలింగ్ ఎలాంగ్ విత్ పబ్లికేషన్, ఎలాంగ్ విత్ ఎగ్జామినేషన్, 3 ఒకసారి అనుకోండి, మీకేమవుతుంది, పబ్లికేషన్ ఫైలింగ్ ఏంటో పబ్లికేషన్ కి 18 months, అక్కడ ఎగ్జామినేషన్ కి 18 months. ఎగ్జామినేషన్ మీరు ఫైల్ 4000 ఫీజు కట్టాలి, ఆ ఫీజు కడితేనే ఎగ్జామినేషన్ కట్టాలి, లేదా పోతుంది. అంటే ఇనిషియల్ గా 8100 రూపీస్ కానీ ఇనిషియల్ వేళ కట్టారనుకోండి, మీకు మీ పబ్లికేషన్ అయ్యే టైము, నెక్స్ట్ ఆ ఎంబ్రిగో పీరియడ్ టైం అంటే 4 years మీకు కలిసి వస్తుంది, 2 to 4 years. అర్థమైందా?
Sir. Okay. Thank you, sir.
ఓకే
Good afternoon, sir.
సార్ సార్ ఇంకా కంప్లీట్ అవ్వలేదు ఇట్లా సెషన్ బోల్డ్ ఉంది ఇంకా చెప్పండి.
Sir, next month, sir.
ఎస్ సార్.
Sir, my paper was published in Wireless Personal Communication, Springer.
ఓకే బ్రింగ్
Last month,
Q1 I think Q1 journal. Yes.
Q1 journal, sir. So, how do you know that it is a novel? It is a new novel, and how will decide that one? It is novel idea.
ఎస్ దిస్ ఈస్ వెరీ థింగ్ సార్. ఇది నావల్ వర్క్ అని ఎవరు చెప్తారంటే ఫస్ట్ మీకు చేసిన వర్క్ నావల్ అంటే మీకు తెలియాలి ఫస్ట్.
Okay.
పాయింట్ నెంబర్ వన్ మీ వర్క్ ని ఏంటి, యు ఆర్ ద సోలో ఇన్నోవేటర్. దాన్ని మీరు ఎలా చేశారంటే చాలా వరకు ఆర్కిటెక్ట్ వర్క్ కింద చేస్తారు, కానీ మీరు ఆ వర్క్ ని ఇంప్లిమెంట్ చేసి త్రూ ఎక్స్పెరిమెంట్ రిజల్ట్స్ తీసుకొస్తే అది కంప్లీట్ నావల్టీ వర్కే. ఆ నావల్టీ వర్క్ మీరు ఏం చేశారంటే పబ్లిషర్కి ఇచ్చారు, పబ్లిష్ చేయడానికి. వాడికి కేవలం ఉండేది పబ్లికేషన్ రైట్స్ మాత్రమే. ఆ వర్క్స్ లో ఆ కంప్లీట్ రైట్స్ మీకే ఉంటాయి.
Okay, sir.
అయితే ఇక్కడ మీరు చేయాల్సింది ఏంటంటే ఈ ఏదైతే మీరు పేపర్ రాసిన డ్రాఫ్టింగ్ రాశారో ఆ డ్రాఫ్టింగ్ అనేది మీరు పేటెంట్ రాస్తున్నందుకు ఆ డ్రాఫ్టింగ్ సరిపోదు.
Okay, sir.
ఆథర్ ఆఫ్ వర్క్ వేరు, పేపర్ పబ్లికేషన్ వర్క్ వేరు. ఏంటి అబ్స్ట్రాక్ట్, ఇంట్రడక్షన్, లెటర్స్ వర్క్స్ అండ్ రిలేటెడ్ వర్క్, ఎక్స్పెరిమెంటల్ వర్క్, రిజల్ట్స్, అనాలిసిస్ అండ్ కన్క్లూజన్, ప్రపోజ్ సిస్టమ్, ఎగ్జిట్ సిస్టమ్ అండ్ కన్క్లూజన్, ఫ్యూచర్ ఎన్హాన్స్మెంట్ ఇలాగ వస్తుంది. కానీ కంప్లీట్ గా పేటెంట్ ఫైలింగ్ వచ్చేసరికి దాని డ్రాఫ్టింగ్ వేరు. అంటే మీ నావల్టీ వర్క్ ఏదైతే అనుకుంటున్నారో ఆ నావల్టీ వర్క్ ని సిమిలారిటీస్ అనేది చాలా తక్కువ ఉండాలి. పేటెంట్ రైట్స్ వచ్చేసరికి 0.5% నావల్టీ ఉంది, 0.5% ప్లాగరిజం ఉండాలి. అది ఫస్ట్ థింగ్. ఇది 0% కానీ ప్లాగరిజం ఉందనుకోండి 100% మీకు గ్రాంట్ వచ్చే ఛాన్స్ ఉంది.
Okay, sir.
ఓకేనా? అప్పుడు మీరు ఏదైతే పేపర్స్ రాశారో ఆ పేపర్స్ ని ఆ పేటెంట్ డ్రాఫ్టింగ్ ఉంటుంది, ఆ డ్రాఫ్టింగ్ లో కానీ పర్ఫెక్ట్ గా మీరు మ్యాప్ చేయగలిగితే, మీ ఐడియాని దానికి తగ్గట్టుగా మీరు ప్రొజెక్ట్ చేయగలిగితే దట్ విల్ వర్క్ సార్. కాకపోతే ఇక్కడ మీరు ఏదైతే పేపర్ టైటిల్ వేశారో ఆ టైటిల్ తో మాత్రం అక్కడ ఫైల్ చేయకూడదు.
Sorry, sir.
ఎందుకంటే ఆ అబ్స్ట్రాక్ట్ ఫైల్ చేయకూడదు. అబ్స్ట్రాక్ట్ ఆల్రెడీ మ్యాప్ అయిపోయింది. అబ్స్ట్రాక్ట్ అదే వర్క్ ని రిలేట్ చేసేసి కొంచెం అబ్స్ట్రాక్ట్ మార్చి న్యూ థింగ్స్ ఇంకో 2-3 యాడ్ చేస్తారు. ఫస్ట్ వన్. సెకండ్ వన్, టైటిల్ సిమిలర్ రావాలి తప్పించి అదే ఒక టైటిల్ పెట్టుకుంటే మీ మీద మీకే కాపీరైట్స్ అనేవి కంట్రోల్ అయిపోతాడు. ఎందుకు? పబ్లిషర్ కంపెనీ వాడు కంట్రోల్ అయిపోతాడు. ఎందుకంటే ఆల్రెడీ ఈ టైటిల్ తో నీ వర్క్ నాకు ఇచ్చావు, మళ్ళీ నువ్వు ఏ రకంగా మళ్ళీ నువ్వు క్లెయిమ్ చేసుకుంటే అదే వర్క్ అడుగుతాడు అనమాట. అంటే వే ఆఫ్ డ్రాఫ్టింగ్ మారిపోవాలి ఫస్ట్ వన్. దాని తర్వాత ప్రొజెక్షన్ వే కూడా మారాలి.
Okay, sir.
అర్థమైంది సార్?
Okay, sir. Okay, sir. Advance.
Sir, any doubts regarding patents and corporates? Then we will plan to go trademark. Hello?
Continue, sir.
Continue? Can I continue?
Okay.
I think, Krishna sir.
Sir, tell me, sir.
Sir, one more thing. I think nearly this very big session. I think, but right now we discuss on patents and what is the corporates and what is the patents and what is the designs. Okay,
Okay.
corporates. And we right now we are planning to extend our session in another way, another day. ఎందుకంటే మనం ఇప్పుడు వరకు కేవలం ఐపీఆర్ చెప్పుకున్నాం, ఎవల్యూషన్ చెప్పుకున్నాం, పేటెంట్స్, కార్పొరేట్స్ మాత్రమే చెప్పుకున్నాం.
Okay, tomorrow after 4:30, sir.
వన్ మోర్ థింగ్ సార్, ఇంకా మనం చెప్పుకోవాల్సినవి డిజైన్స్ ఉన్నాయి, ట్రేడ్ మార్క్స్ ఉన్నాయి, జియోగ్రఫికల్ ఇండికేషన్స్ ఉన్నాయి. ఈ మూడుతో పాటు లైవ్ లో మనకి పేటెంట్స్ ఎలా ఫైల్ చేయాలి అనేది లైవ్ లో చూపించాలి.
ఓకే.
చూపించాలి, ట్రేడ్ మార్క్స్ ఎలా డిజైన్ చేశారు. నెక్స్ట్ మీకు నేను పేటెంట్స్ చూపించాను, పేటెంట్స్ చెప్పాను కానీ అది ఎలా ఫైల్ చేయాలో చెప్పలేదు. నెక్స్ట్ దాని తర్వాత డిజైన్ కాపీరైట్ చెప్పాను కానీ అది ఎలాగా మీకు దేని ద్వారా ఏ పబ్లికేషన్ ఏ మీడియం ద్వారా మీకు నేను కాపీరైట్ ఫైల్ చేయాలి. ఐదర్ మనకి ఇండియాలో అయితే ఎలా ఫైల్ చేయాలి, ఫారెన్ లో అయితే ఎలా ఫైల్ చేయాలి, ఏ కంట్రీకి మీకు ఎలాగైతే ఎలా ఫైల్ చేయాలి అంటే ప్రతి కంట్రీకి కూడా ఫైలింగ్ మెకానిజం ఎలాగ ఉంటుంది అనేది చెప్పాలి. ఈవెన్ ట్రేడ్ మార్క్స్ ఆల్సో మీకు మీరు ఎలాగ ఫైల్ చేసుకోవాలి. త్రూ కన్సల్టెన్సీ వర్క్ చేసుకుంటే బెనిఫిట్స్ ఏంటంటే ఈ నెంబర్ ఆఫ్ ఉన్నది. అది ఈ తక్కువ టైంలో చెప్పడం కన్నా మళ్ళీ మనం నెక్స్ట్ వీక్ కానీ మనం ప్లాన్ చేసుకున్నాం, నెక్స్ట్ వీక్ ప్లాన్ చేసుకున్నా చేసుకుంటే నెక్స్ట్ సండే ప్లాన్ చేసుకుంటే దీన్ని అప్కమింగ్ సిరీస్ అనేది కంటిన్యూ చేయొచ్చు.
ఓకే సార్, నో ప్రాబ్లం.
సార్ ప్రిన్సిపల్ సార్.
Sir, okay, sir, no problem, sir, because it is already 2.5 hour session, this one.
Yes,
Yeah,
sir.
it's like most of the people, they may
Yes, sir.
left, I think.
Yes, sir.
We will continue this one in the next week, sir.
Yes, sir. Series of workshop means it's give the immense knowledge, sir. I think
Yeah.
share the knowledge. Okay, sir. I think next week we will plan to explore and other topics along with real time how
Okay,
to file a process, sir.
Okay,
Definitely, sir. Okay. Thank you for giving the opportunity, sir. Next,
okay,
sir. And principal, sir.
Okay, sir, welcome, sir. We will meet in next week.
Yes, sir.
Krishna Reddy,
sir.
Vote of thanks, sir.
One second, sir. Mahalakshmi madam, are you there?
Yes, sir. Yes, sir.
Okay, madam. You can propose vote of thanks.
Okay, sir. Fine. So, good afternoon, everybody. On behalf of Electrical and Electronics Department of Mother Theresa Institute of Engineering and Technology, I would like to thank the Chief Resource Person of this event, Mr. Bosubabu Sambana, innovator of Internet Protocol version 16, for giving the valuable information regarding patent copyrights, which are more helpful in today's working sector. Thank you very much, sir. I would like to thank the chief patron for the event, Mr. M. Ravindra Babu, Correspondent Secretary, and Mr. M.R. Sunil, sir, Chairman, and Dr. R. Rajendra Reddy, sir, the Academic Director. And I would like to thank the patron for the event, Dr. M. Lakshmikanta Reddy, sir, Principal of Mother Teresa Institutions, and Dr. R. Saravanan, sir, Director of Academics. And I would like to thank all the department HODs and colleagues. And I would like to thank the convener of the event, Mr. K. Krishna Reddy, Associate Professor of EEE Department. And I would like to thank the coordinator of the event, Mr. N.B. Kishore Kumar, sir, Associate Professor of EEE Department. So finally, I would like to thank all the participants who have attended the event and making it a grand success. Thank you, and all.
Thank you very much. Thank you very much, sir, Principal, sir.
Thank you, sir, Bosubabu, sir. Thank you to all.
Thank you, sir. Thank you very much. We will continue in next week.
Thank you, sir.
Next week. Okay.
Thank you, sir.
Thank you, sir. Thank you very much.